Right? Correct. It's excuse only. Which one you didn't write? Why the next three? Okay. So your first excuse is done. I don't want to come for begging now. So I'll give you a fair option only. So I always give first excuse. So first excuse is utilized. Everyone. Everyone. If I give means it will next jurisprudence also will end. So next any one person not writing assignment, assignments will be discontinued. Hey, not now, next time. Now excuse is done. I'll still give but next time you don't write, it will be discontinued. Yeah, no 3 strikes and all. Now concentrate. Clear? All of you. You should have checked it. You will check whether he had food or not. He ate or not and all. You will check. Can't you ask him whether he asked, what is that? He sought questions or not? Everything I'll discuss only, no? First I'll discuss that. If you have any doubts, then you let me know. Yes, Okay, so for all of you, remember, excuse is done now. Now don't do anything. Clear? Okay. A company wants to include a provision in its articles of association by altering them to limit the company share capital to a fixed amount. Can it do so? Will your answer be different if 100% of the shareholders agree for such alteration? Is it possible is what they are asking you. A company wants to include a provision in its articles of association by altering them to limit the company's share capital to a fixed amount. Question 1, can it do so? Second one, will your answer be different if 100% of the shareholders agree for such alteration? Can they do so? Is it possible? Why no? You can write internal terms, internal conditions, right? Correct. But you can write it in the answer in such a way that a company can alter its articles of association in such a way that they restrict the capital clause, but not in violation to their MOA. Meaning they cannot have a different amount here, they cannot have a different amount there. But can they alter? The answer is yes. Now can they say that it cannot go beyond a particular amount? Answer is yes. You can call it as an alteration of article clause. What is the procedure? You just need to pass special resolution. You will file form MGT 14, and if it is entrenchment, then if it's public company or private company, that makes difference. In this case, they have never mentioned which type of company, so you are very lucky. So this information doesn't make much difference here. Public also, private also with 100% is possible now. But if they had asked you which type of company, you need to remember for entrenchment. For a private, all members have to agree. Then only this is possible. Correct? For a public, special resolution will do. So first of all, the answer. Is it possible? Answer is yes, possible. Just that it should not be in violation to MOA. Correct. Ultra wires not possible. That circle will come into picture. So can the company restrict? Answer is yes, possible. Clear? Rota? Okay. Today in the break, randomly I'll be picking up 3 books. I'll be checking your answer. Anyone else who didn't write? Assignments? All of you wrote no. So I'm just telling you because I should not give you surprise and all. No. Answer is wrong. I'm okay. But I'm telling in the break, I'll be picking 3 books. I'll be checking your answer. Okay. Anushka Security Equipments Limited is a manufacturer of CCTV cameras. It has raised 100 crores through public issue of its equity shares for starting 1 more unit of CCTV camera manufacturing. It has utilized 10 crore rupees and then it realized that its existing business has no potential for expansion because of government has reduced customs duty on import of CCTV cameras. Hence, import imported cameras from China are cheaper than its own manufacturing. Now it wants to utilize the remaining amount in mobile app development business by adding a new object in its MOA. Does the Companies Act allow such change of object? If not, then what advice will you give the company? If yes, then give steps to be followed. What is the answer? Yes, it can be done. So what is the section? Section 13. So what is the procedure? Special resolution? Published in newspaper? Alter AOA? Okay. Filing in MGT 14. So it is nothing but alteration of MOA. That's all, no? Yes or no? When we are seeing, we have to see questions very carefully. They have raised money through public issue. Public issue means what, people? One thing that will mandatorily come into picture is nothing but prospectus. It's not a privately raised money. It is a company that has raised money through prospectus. So can the company change? What Abhijit, can they change? Is it possible to utilize that money for app development? Can they do it? The procedure involved here is you need to pass special resolution. You need to give exit opportunity. You need to make sure that the money is not invested in equity shares of another listed company. Anyways, they are giving app development, so it's not being used for investment. That is okay. And you have to give newspaper, that website, that is mandatory. And you will have to make sure object clause is altered. That is the answer. What is the answer? You need to read section 13 and section 27. Both are to be read together. That is this particular provision. Clear? I don't know how many of you wrote. Online able to understand? For now, for this, no, not required.
When we are teaching you said that name in being like the object of the explanation. So they have to change the name.
Name? No, not required. But you do not know their name, right? Okay, they are telling Anushka Security Equipments Limited. Now they were into CC cameras. Now they want to do some app development. What is that app development for? I mean, in general, what is it for? Can I say for CC cameras only app? I'm not sure. I'm asking you. So when it is not given on those grounds, why do you want to assume it? I'm not saying your thought is wrong. It is right only. You can think on that SEBI LODR regulation 45 grounds also. That is correct only. But when they have not given that, why do you want to create your own problems? Correct? No. But yes, what you said is correct only. Which one? Correct. Now what he is telling is, if a new line of business is started, now we do not know what is app development, no? Now if you sell CC cameras, I think you also know, along with that one app will come to view those things. Now why can't it be that also? I'm not sure, I'm just telling you. What I'm saying is when the question is not being directed to it, they're clearly telling you, can they add a new object in its MOA? Why do you want to think of name clause? If they have given a blank question, then think of name clause also. Yes, your understanding is correct. Does it make sense? No, 100% wrong. You could write that. Correct. Notice, yes, it will be, because when you are filing MGT 14, the notice sent to the shareholders will be attached in the form MGT 14, so it will become public document. Postal ballot only, yes. We have written no postal ballot. Okay. Yes, specialization through postal ballot only. Yes. It has to be through postal ballot. Clear now? Hello? Okay, next one. Manglu and Friends got registered a company in the name of Taxman Advisory Private Limited. Taxman is a registered trademark. After 5 years, when the owner of trademark came to know about the same, it filed an application with relevant authority. Can the company be compelled to change its name by the owner of trademark? Can the owner of registered trademark request the company to change its name of its direction? 3 years time is there. Within 3 years they have not gone, so they lose a right to go and ask for the name change. Correct? What which section? Section 16, which speaks about mandatory name change. Whenever registered trademark holder within 3 years of incorporation comes and applies for the same name being same as their name, they can request for a name change. This person came after 5 years. So can this person request for a name change? No, not possible. So that there ends your answer. They have asked, always remember in your exam, read the question carefully. There are two questions. The second part of the question says, can the owner of registered trademark request the company to change its name at its discretion? I cannot compel you, but can I request you? Yes, it will come under voluntary name change, 13(2). Now, yes, company at its discretion, if they want to, they can change, but not mandatory. Agreed? Hello? Okay, that's your answer. Question, what is that? Provision will be as per section 16. Rectification of name has to be done within 3 years of incorporation of a similar company with name. If it is not done, not possible. Done now? Hello? Section 13, voluntary.
There are two options. One, if the central government sees that
Correct.
existing company.
Correct.
So after 5 years, the existing company goes to the central government and says that the company which has the same trade. Now it is not for the central government. Right?
Correct.
Not their change.
Now, central government's discretion. Now, there are two ways to look at it. Central government may prefer to help you. Second, central government can also tell you were negligent for 5 years, I will not help you. The chances of second one is more because limitation act is there. They will not help you. It may happen. That's what. Again, central government's discretion. But the chances of central government helping is very, very less. They will say it is a limitation. Logically think why. If they start helping you, that means they are inviting everyone who is having this dispute to come and refile your cases again. I will look into it. That's why they would not help. 10th one. X Limited has equity shares with voting rights that are pari passu. X Limited, what do you mean pari passu? Pari passu means there is no differences. Everything is same. No DVR, no SR, no normal share. Everything is same. Latin. Everything is Latin. Wherever we are using these words, ultra wires, all that, everything is Latin. It's more like Vipasa Basu. Okay. Pari passu. So X Limited, Y Limited and Z Limited each hold 20% of equity shares in S Limited. Whenever they are giving you shares, whenever they are giving you proportion, first write off S Limited, there is X, Y, Z, each 20% of equity shares in S Limited. Correct? The remaining 40% of shares are held by retail investors. R Limited controls the composition of board of directors of X Limited, Y Limited and Z Limited. Their companies R controls the board of composition of X, Y and Z. Correct? Based on the provision of Companies Act 2013, determine the status of R Limited. Now, what will your answer be? What is the provision? Section 2, clause 87, as per subsidiary company definition. What is a subsidiary company? A company which controls the composition of board of directors of another company. The company being controlled is always subsidiary company. So X, Y, Z are being controlled. Hello. So by default, these three companies, all three became subsidiary companies. Sir, and these three people are holding 20, 20, 20 each in S company. Now, subsidiary company second definition is what? When a company holds more than one half of the total voting power, either on its own or together with its subsidiary, it will be called as a subsidiary company. So, S Limited is a subsidiary of R Limited. Deemed is third one, no? I hold in you, and that person holds complete part in them. If you add everything, no, that will come when R is holding X 51%. X is holding in Y 51%. This is deemed subsidiary. Direct subsidiary. I am both are valid only, but I can write this one because it's clear. No, hey, I'm telling you the definition. What when a company holds more than one half of the total voting power, either directly or through its subsidiaries. Correct? No. Now, can I say it's not a deemed company? Deemed also it will come. Correct. Deemed also is valid only. I wouldn't say that is not valid. That is also valid only. But more appropriate will be the subsidiaries. When you are writing subsidiary company definition and you are writing the answer. Answer is correct only. Because both also there in subsidiary company only, no? Yes or no? But that is more apt. Okay. Next one. Lalit began the discussion by informing the group that his client Rupam Leathers Limited changed its name to Rakshak Leathers Limited in Jan 2024. Following, this was the June 2025 question. Following 4 months, following the process of law, before this change, the company had filed a suit against one of its suppliers in May 2023 to recover compensation due to breach of a contract. However, in April 2024, the supplier applied to the court for dismissal of the suit, arguing that Rupam Leathers Limited ceased to exist after the name change and the issuance of a new certificate of incorporation by the registrar. The managing director of the company has expressed concern about the fate of the litigation against the supplier. What is the answer? Effects of name change. There is that Malati tea and that fiberglass. That case law you need to write. Correct? What is the legal effect of name change? The proceeding shall continue in the new name. It will not come to an end. And forming of a new name doesn't mean it's new company coming into existence. It is a continuation of the old company. Third one, it is not an incurable defect. A plate can be amended. That was a glass fiber. That is the answer you need to write. Legal effect of change of name. Section 13 only. Name change only. Name change in name clause. But more accurate one is this. So here, no, it is not considered like that. The name, whatever is the case, will continue in its new name. Agreed? Hello? Malati tea. Glass fiber. Correct? Explain the concept of indoor management with exceptions of forgery and negligence as per Companies Act 2013. So you are writing indoor management. Why did I give you this? Do not get confused. It's not only indirect questions. Direct questions will also be asked. And it's not like you remember 4 points and go. You getting it? Exceptions to indoor management, what you will think? They will ask exceptions to indoor management. I will know 2 to 2 points in everything I am done. What they have asked here, see, specifically they have asked you forgery and negligence. So you knowing every place 2 to 2 will not work out here. So such type of questions will also come to just remind you. That is why I have just put this. Or else it's a direct, easy question. No complication at all. Clear all of you? Pakka? Okay. So these are the case laws.